Продолжаем заседание.
We shall continue with our meeting and move to consider items 5 and 6 of the agenda, asset recovery and international cooperation. I'd like now to open this session. So we'll be discussing these two items together, as we did at the last session of the conference. This organization of work aims to create synergies between the discussions on the implementation of the two chapters of the Convention, in particular the discussions on mutual legal assistance and law enforcement cooperation, since these are closely linked with the discussions on Chapter 5 on asset recovery. But also problems of extradition and asset recovery are also linked in practice, so that it is expected that the discussion of the two chapters together can be fruitful. With regard to agenda item 5, entitled Asset Recovery, Resolution 5/3 of the conference adopted at its last session in Panama renewed the mandate of the open-ended intergovernmental working group on asset recovery and decided that it should continue its work of advising and assisting the conference in the implementation of its mandate on the return of the proceeds of corruption. Pursuant to Resolution 5/3, two meetings of the working group were held in Vienna on the 11th and 12th of September 2014 and on the 3rd and 4th of September 2015 in Vienna also. Pursuant to its work plan, at its 8th session, the working group held a thematic discussion on Article 52, prevention and detection of the transfer of proceeds of crime, and also Article 53, measures for direct recovery of property. At its 9th meeting, the working group held a thematic discussion on Article 57, return and disposal of assets. The working group also held discussions on advancing practical aspects of asset recovery, including challenges and good practices, as well as on updates and developments relating to thematic discussions at its 6th meeting, and also on capacity building and technical assistance. The reports from these two meetings of the working group have been provided to states parties in advance of this session. The document references are CAC COSP WG2 2014-4 and CAC COSP WG2 2015-4. Further to its considerations, the conference also has in front of it a background document entitled Progress Report on the Implementation of the Mandates of the Working Group on Asset Recovery. The document here is CAC COSP 2015/3. I now have the pleasure of giving the floor to the Secretariat to introduce the background document. Secretariat, the floor is yours.
Thank you very much, Mr. President. Under this agenda item, we would like to provide an update to the conference on the progress of work since its last session with regard to its mandate on asset recovery. The conference established in its Resolution 1/4 the open-ended intergovernmental working group on asset recovery to advise and assist the conference in the implementation of its mandate on the recovery and return of proceeds of corruption. The working group has, since the beginning, held 9 intersessional meetings. To begin with, let me give you an update on the last 2 intersessional meetings of the open-ended intergovernmental working group on asset recovery, held since the latest session of the Conference of States Parties. Pursuant to the work plan established in 2012, the working group held 2 thematic discussions in 2014. The first one on Article 52, relating to the prevention and detection of transfers of proceeds of crime, and the second one relating to Article 53, concerning the measures for direct recovery of property. This year, the working group held a thematic discussion on Article 57, on the return and disposal of assets. The working group recommended, inter alia, that further information should be collected regarding international cooperation in civil and administrative proceedings for the identification, freezing, and confiscation of assets in order to identify the scope of assistance that could be provided in relation to such proceedings. The working group also recommended that non-binding guidelines on asset recovery should be further developed with a view to enhancing effective approaches to asset recovery. Furthermore, the working group also welcomed the preparation and dissemination of practical guides by states on their legal frameworks, mechanisms, and procedures for asset recovery as a useful tool for requesting states. And the working group also recommended to states parties and to UNODC to continue sharing their experience on the management, use, and disposal of frozen, seized, and confiscated assets, to identify best practices, and to consider developing non-binding guidelines on this issue. I would now like to give you some updated information on the implementation of the mandates of the conference and of the working group since the 5th session of the conference held in Panama in 2013. As you know, the working group has structured its work on 3 main themes. First, developing cumulative knowledge. Second, building confidence and trust between requesting and requested states. And third, technical assistance, training, and capacity building. With regard to the development of cumulative knowledge, let me provide some further details. For the development and management of cumulative knowledge, one of the main tools is the portal Tools and Resources for Anti-Corruption Knowledge, also called TRAC. A special section of TRAC is dedicated to asset recovery. It contains the legal library with legislation of 176 countries, searchable by provision of the Convention. Further, the following databases are also accessible through TRAC. Asset Recovery Watch, which is a database developed by the joint UNODC and World Bank Stolen Asset Recovery Initiative, the STAR initiative. It contains information on 225 past and current asset recovery cases. A database of grant corruption cases is also accessible. This database contains cases, grant corruption cases, that involve the misuse of legal structures to conceal the ownership of stolen assets, known as the Puppet Masters database of grant corruption cases, by the title of a study published by the STAR initiative on these cases. And a database of nearly 400 settlement cases, that is, any procedure short of a full trial to conclude foreign bribery cases. TRAC also contains the 14 country guides developed as part of the action plan on asset recovery of the Deauville Partnership with Arab countries in transition, and the guides of 5 more countries produced following a call by the Secretariat to do so, in order to assist requesting states parties in developing meaningful and successful mutual legal assistance requests. The policy studies produced by the STAR initiative have been widely recognized as useful in addressing knowledge gaps in specific areas of asset recovery. Since the last session of the conference, 2 new studies have been published. The first one is a study entitled Few and Far: The Hard Facts on Stolen Asset Recovery, which was produced by the STAR initiative and the OECD. It presents performance data from 34 OECD countries on cases involving frozen or returned assets in the context of international asset recovery proceedings. One of the findings was that in recent years, there has been an increase in frozen assets compared to the period of 2006 to 2009. Also, it was found that an increasing percentage of returned assets went to developing countries. However, overall progress remains limited when compared to the estimates of the assets stolen at a global level. The second publication is entitled Public Wrongs, Private Actions: Civil Lawsuits to Recover Stolen Assets, and sets out step-by-step guidance on the use of civil lawsuits and civil remedies to recover stolen assets, and illustrates the advantages that civil claims can bring if compared with pursuing only criminal proceedings. Following another observation of the conference, the draft guidelines for the efficient recovery of stolen assets were developed during a workshop held in Lausanne, Switzerland in January 2014, and presented to the 8th session of the working group also in 2014. The government of Switzerland and the International Center for Asset Recovery, supported by the STAR initiative, are working on explanatory notes to the draft guidelines. In August of this year, UNODC published a digest of asset recovery cases. It provides factual examples of cases organized in thematic sections that follow the structure of the convention, with summaries for policymakers and practitioners drawn from the cases examined for each section. The digest is a first comprehensive approximation to the question how the mechanisms for asset recovery contained in the convention have actually been applied in concrete cases over the past decades. I would also like to make reference to the revised draft self-assessment checklist for the review of Chapter 5 of the Convention, which will be and which has already been under more detailed discussion in other meetings of this session of the conference. It is available in all languages. The structure and content of the self-assessment checklist is of particular importance in connection with the development of cumulative knowledge, since it will be the basis for the most comprehensive and inclusive information gathering exercise on asset recovery, which will be conducted in the context of the review of Chapter 5 under the implementation review mechanism. Finally, on the issue of knowledge development, I would also like to mention two substantive areas of special interest to the working group. The first one, the international cooperation in civil and administrative proceedings relevant to asset recovery. The Secretariat invited states parties to share their experience in this regard. An analytical report on the subject has been presented to the open-ended intergovernmental expert meeting held on Monday and Tuesday, 2nd and 3rd of November, here in St. Petersburg. You will receive a presentation from my colleague on the document and an update on the proceedings of that expert meeting later during the agenda item on international cooperation. Second, in 2014, UNODC started a cooperation with the region of Calabria, Italy, which looks into the management, use, and disposal of frozen, seized, and confiscated assets. The aim of the initiative is to identify good practices and develop relevant tools and guidelines on the administration of seized and confiscated assets. This refers to cases both at the domestic level as well as in the context of international asset recovery. Two expert groups were held in April 2014 and September 2015. The first one produced a set of findings and recommendations on how to advance the work of the international community in identifying, seizing, and confiscating criminal assets, with a specific focus on the proceeds of corruption. It also discussed the domestic management, use, and disposal of seized and confiscated assets, and the management of returned assets in asset recovery cases. The second meeting, which focused primarily on the management of seized and confiscated assets in the context of domestic cases, resulted in a collection of national experiences and good practices with regard to measures to maintain the value of assets, institutional frameworks, and specialized agencies, the concept of social reuse, the creation of databases to support the management and disposal of assets, and training programs for stakeholders involved in the management of seized and confiscated assets. The report of that meeting can be accessed under document number CAC/COSP/2015/CRP6. Turning now to the measures to build and strengthen confidence and trust between requesting and requested states. Those measures comprise both the work of various international and regional networks of asset recovery practitioners and political advocacy for the lowering of barriers through asset recovery in different policy fora. The Global Focal Point Initiative, supported by Interpol and the STAR Initiative, held its 5th annual general meeting in Vienna in September 2014. The meeting addressed topics such as asset recovery in the cyber era, plea bargaining, parallel investigations, and joint investigative teams. The 6th annual meeting will be held from 17th to 19th of November this year, so in only 2 weeks to come, in Delhi, India. The event will take stock of the initiative and the use of the secure ISACOM platform. Further, the regional asset recovery networks will also participate, and an expected outcome of the meeting will be to enhance collaboration and coordination among those networks and the global network. UNODC and STAR continued their support for regional networks engaged in asset recovery, notably for the Asset Recovery Network of the Financial Action Task Force of Latin America against money laundering, RRAG for its Spanish initials, the Asset Recovery Interagency Network for Eastern Africa, the Asset Recovery Interagency Network for Asia and the Pacific, the Asset Recovery Interagency Network of Southern Africa, and for a new network, the Asset Recovery Interagency Network for West Africa, which was established in November 2014 with support of the UNODC Global Program Against Money Laundering, Proceeds of Crime, and the Financing of Terrorism. The STAR initiative also holds an observer position in the Camden Interagency Network on Asset Recovery. UNODC and STAR engage actively in advocacy in a number of international fora to strengthen political will and lower barriers to asset recovery. As observers of the meetings of the G20 Anti-Corruption Working Group, they actively participated in the development of the G20 Anti-Corruption Action Plan and the G20 Anti-Corruption Implementation Plan for 2015-2016. They also contributed to the development of the G20 high-level principles on beneficial ownership transparency. The STAR initiative also works closely with the Financial Action Task Force. The FATF issued guidance on transparency and beneficial ownership. It calls upon countries to take specific measures that closely echo the recommendations contained in the STAR initiative study entitled "The Puppet Masters: How the Corrupt Use Legal Structures to Hide Stolen Assets and What to Do About It." The STAR initiative supports the Arab Forum on Asset Recovery. This is an initiative to advance the implementation of the Deauville Plan of Action on Asset Recovery and aims to assist various Arab countries in their ongoing asset recovery efforts. The 3rd meeting of the Arab Forum was held in November 2014, hosted by the government of Switzerland and co-chaired by Egypt and Tunisia. Germany, as chair of the G7 in 2015, then organized a special session in Tunis in May 2015 for the exchange of technical and tactical information. The special session consisted of a general technical and a capacity building part and a country-specific part for Tunisia. The 4th Arab Forum on Asset Recovery will be hosted by Tunisia from 8th to 10th of December of this year with the support of the German presidency of the G7, the State of Qatar, and the STAR initiative. It will focus on Tunisian efforts and cases in different jurisdictions, and the substantive sessions will highlight prevention as well as innovative instruments to recover assets. The meeting will also focus on lessons learned and stock-taking in order to achieve greater successes in asset recovery. Finally, let me briefly touch upon the area of technical assistance, training, and capacity building. UNODC including through the STAR initiative, continued to provide technical assistance to states in their asset recovery efforts. Since the last session of the conference, 27 countries, 2 asset recovery forums, and 2 regional networks received such assistance, and new requests were received from 3 countries. Country assistance constituted approximately 60% of the activities of the STAR initiative. You will find examples of country-specific technical assistance in Botswana, Mongolia, Tunisia, Uganda, Moldova, and Tanzania in the background document. These examples are meant to show the broad range of technical assistance methodologies used by the STAR initiative, while at the same time respecting the confidential nature of other STAR country engagements. Since the last session, STAR has also implemented a number of regional technical assistance initiatives. The initiative supported the enactment and implementation of non-conviction-based forfeiture legislation in Central America. A regional workshop was held in Tehran in March 2015 on investigative techniques for transnational corruption offenses. The meeting was attended by senior practitioners from 7 countries. For West Africa, a regional workshop on money laundering was held in Dakar for prosecutors and investigative judges from 5 West African countries. One important element of STAR assistance is the facilitation of bilateral and multilateral case coordination meetings. STAR facilitates such meetings within its country engagements and on an ad hoc basis, and also at the occasion of multilateral events such as the open-ended asset recovery working group or the meetings of asset recovery networks. On the margins of the 5th annual meeting of the Global Focal Point Initiative, supported by Interpol and the STAR initiative, 23 formal bilateral consultations were facilitated to discuss pending or upcoming cases, and a number of informal bilateral case discussions were held at the margins of the meeting. During the 3rd meeting of the Arab Forum on Asset Recovery, more than 70 bilateral meetings were facilitated. And with this, I would also like to wish the conference fruitful deliberations on asset recovery, and thank you very much, Mr. President.
Many thanks for all of that information. With regard to agenda item 6, the conference adopted at its 4th session the resolution 4/2 entitled Convening of Open-Ended Intergovernmental Expert Meetings to Enhance International Cooperation. It decided that the expert meetings should perform the function to, inter alia, assist the conference in developing cumulative knowledge in the area of international cooperation, in encouraging cooperation among relevant existing bilateral, regional and multilateral initiatives. It should further facilitate the exchange of experiences by identifying challenges and good practices and assist the conference in identifying the capacity building needs of states. In accordance with its resolution 5/1, the conference decided that on a provisional basis and without prejudice to their independent status and mandates, the 3rd open-ended intergovernmental meeting of experts on international cooperation under the United Nations Convention Against Corruption shall be held back-to-back with the corresponding working group on international cooperation under the United Nations Convention Against Transnational Organized Crime when feasible, at separate times and at the same venue, and that the subsequent open-ended intergovernmental meeting of experts shall be held at the present 6th session of the conference. Pursuant to the above-mentioned resolution, the 3rd meeting of experts convened to enhance international cooperation under the UN Convention Against Corruption was held in Vienna on the 9th and 10th of October 2014. The meeting of experts recommended the organization of regular meetings for central and other competent authorities of states, parties and signatories to the convention under the aegis of the meeting of experts convened to enhance international cooperation under the convention. The meeting of experts also recommended the Secretariat continue to compile information from states parties on international cooperation in civil and administrative proceedings for the detection of corruption offences. Furthermore, the meeting underlined the importance of further efforts to enhance the operational capacity of central or other competent authorities involved in international cooperation on criminal matters. The report of this third meeting has been provided to states parties in advance of this session. The document reference is CAC COSP EG1 2014/3. I'd also like to draw delegations' attention to a document prepared by the Secretariat entitled Note by the Secretariat on International Cooperation in Civil and Administrative Proceedings for the detection of offences established in accordance with the United Nations Convention Against Corruption. The document reference is CAC COSP EG1 2015/2. The fourth meeting of experts to enhance international cooperation under the Convention was held during the current session of the conference on the 2nd and 3rd of November 2015. I am pleased to ask the Secretariat to introduce the background document and to summarize the outcomes of the fourth meeting of experts to enhance international cooperation under the Convention. Please, Secretariat, go ahead. Thank you very much, Mr. President.
Ladies and gentlemen, I am pleased to give a brief overview of the two documents just mentioned by the President and to summarize the outcome of the fourth meeting of experts. The third session of the Open Intergovernmental Expert Meeting on International Cooperation discussed the outcome of the review process of Chapter 4 of the Convention. The meeting also discussed other practical aspects of international cooperation. In particular, the role of central authorities, flexible application of dual criminality requirements, the importance of informal contacts, networks, and consultation between authorities were mentioned. Additionally, obstacles to law enforcement cooperation in the detection of corruption offenses were discussed. The importance of centralized databases of bank accounts and the specialization of judiciary and law enforcement offices were deemed, among others, as good practices to overcome these obstacles. The meeting produced a comprehensive set of recommendations addressing this and the other relevant matters. The meeting also focused on the issues of international cooperation in civil and administrative proceedings for the detection of offenses under the Convention, including the identification, freezing, and confiscation of assets derived from such offenses. In that regard, the Secretariat presented to the meeting document CAC/COSP/EG1 2014/2, containing information received from 27 states on civil and administrative proceedings. The third expert meeting encouraged states parties to the Convention to assist each other and to engage in international cooperation in investigations of and proceedings in civil and administrative matters relating to corruption. The meeting further recommended that the Secretariat continues to compile information from states parties with a view to presenting a report on this issue during the sixth session of the conference, and recommended the tools that facilitate the compilation and analysis of such information, including the template to be used in that regard. Following this recommendation, the Secretariat produced the Note on International Cooperation in Civil and Administrative Proceedings for the Detection of Offenses established in accordance with the United Nations Convention Against Corruption. That was presented this Monday at the fourth session of the Open-Ended Intergovernmental Expert Meeting on International Cooperation. The note draws attention to the fact that Article 43 of the Convention recognized that for corruption to be countered effectively, civil and administrative proceedings would be a useful tool. As such, it could complement international cooperation in criminal matters. The following are examples provided by states parties which outline administrative and civil proceedings used in corruption cases and in which they have either been successful or would hope to cooperate with other states parties within the framework of the Convention. The first example is enforcement of seizing or freezing orders of an administrative nature or of a judicial decision of non-criminal nature, as well as non-conviction-based forfeiture orders. Another example is liability of legal persons for participation in the offenses established in accordance with the Convention, which are handled differently in different legal systems. Notably, in relation to the nature of liability and the possibility to request and afford cooperation to obtain evidence for use in proceedings against legal persons, or to enforce decisions of a civil, administrative, or criminal nature on assets of legal persons in countries that recognize a different form of liability. Also, another example was provided on legal proceedings to terminate, annul, or rescind contracts and apply penalties based on procurement laws. Investigations related to administrative offenses and gathering of evidence for use in disciplinary proceedings against public officials were also raised as examples. Finally, another example is other special administrative procedures, including procedures initiated by offices of the General Comptroller or Ethics or Integrity Commissioners. Those procedures based on administrative, quasi-judicial examination of public accounts or tax proceedings. The responses of member states provided useful information on their approaches to dealing with international cooperation in such matters. Several states alluded to their ability to afford cooperation on a voluntary basis in civil and administrative proceedings, whenever such cooperation would not be contrary to the fundamental principles of their legal system. Other states stated that their legal systems restricted international cooperation to criminal matters. Several states further emphasized the importance of early consultations between relevant authorities with a view to requesting authorities being well informed before taking decisions as to which form of cooperation to seek and how to build their cases further. The paper concludes with the main recommendation to further advance this knowledge gathering exercise to identify the various civil and administrative proceedings used by states parties to address corruption and to identify the scope of assistance that states would be in a position to afford in relation to such proceedings. At its fourth session, the expert meeting continued the discussion on the cooperation in administrative and civil matters, and also discussed the progress of the review of the implementation of Chapter 4 of the Convention. The Secretariat provided an overview of some of the core findings based on its report called The State of Implementation of the UN Convention Against Corruption. It's a document referenced CAC/COSP/2015/5. The document presents the findings in respect of implementation of Chapter 4 in the form of a more detailed analysis. The meeting also discussed the matters of international cooperation concerning the best ways to identify beneficial ownership. The main conclusions and recommendations of the expert meeting were the following. States should consider increasing their flexibility in affording international cooperation in criminal, civil, and administrative proceedings to accommodate the various approaches chosen by states with a view to depriving offenders of their ill-gotten gains and bringing them to justice. States should consider extending the scope of non-mutual legal assistance-related cooperation or informal cooperation to civil and administrative proceedings independently of whether this could lead to a mutual legal assistance request. States should consider allowing the relevant authorities to directly enforce foreign non-conviction-based confiscation orders. And finally, the conference might wish to consider tasking the Secretariat to conduct a more in-depth study of good practices in the area of international cooperation in civil and administrative proceedings to combat corruption for further consideration of the expert meeting and the conference. That concludes my introduction. Thank you, Mr. President. Ladies and gentlemen, I would like to wish you fruitful deliberations.
Большое спасибо за это.
Thank you very much for all of that information. Distinguished delegates, I would now like to give the floor to member states for their observations and comments in relation to items 5 and 6. We have a list of speakers. We currently have 11 speakers on the list. But anybody who wishes to speak can send a note to the Secretariat, and as we receive requests for the floor, we will enter them on the list. So please take the floor from your seats, and I call first on South Africa, speaking on behalf of the African group. You have the floor.
Mr. President, as highlighted in the statement of the African group during the opening session, asset recovery is a fundamental pillar of the Convention. In this regard, the group attaches great importance to the implementation of the provisions of Chapter 5 on asset recovery. In particular, those related to the freezing, tracing, seizure, and confiscation of illegal assets and the unconditional return and disposal of these assets to their countries of origin. The illicit transfer abroad of public resources compromises the potential for the development of the country of origin, especially in developing countries and the African continent in particular. In this context, the group re-emphasizes that the repatriation of stolen public assets to the countries of origin is an international obligation according to the Convention. However, efforts to repatriate stolen assets and implement Chapter 5 of the Convention are hindered by, amongst others, differences in legal systems, complexity of multi-jurisdictional investigations and prosecution, divergent interpretations of the provision of the Convention, lack of familiarity with the mutual legal assistance procedures of other state parties, difficulties in identifying and exposing the flow of proceeds of corruption, and the lack of political will and cooperation by some of the requested states. This is manifested in settlement agreements reached without consulting the affected countries of origin. As shown in the Stolen Asset Recovery STAR report, few and far the hard facts on stolen asset recovery. For instance, it is disclosed in the report that out of between 20 to 40 billion US dollars estimated to have been stolen each year, only a fraction of it was returned by the requested states. Mr. President, obstacles faced in recovering stolen assets have shown that more needs to be done to strengthen the process and facilitate requesting states in their efforts. The African group urges relevant state parties to eliminate safe havens and lift bank secrecy regulations in order to facilitate the return of stolen assets to the countries of origin. This is in the spirit of the Convention and is consistent with Resolution 5.3 of the Conference, which calls upon state parties to afford one another the widest possible cooperation and assistance in the identification, tracing, and recovery of stolen assets and proceeds of corruption. It is for these reasons that the African group calls upon state parties to support a resolution on asset recovery submitted by Nigeria and the African group. The group believes that the adoption of this resolution by consensus will enhance the effective implementation of Chapter 5 of the Convention and signal our commitment and determination to the fight against corruption in all its manifestations. Thus, the significance of the adoption of this resolution will give impetus to the implementation of the second cycle of review. Thank you.
Большое спасибо.
Many thanks. I'd like next to give the floor to Algeria.
Thank you very much, Mr. President. We are very pleased that you are chairing this meeting and wish to assure you of our full cooperation to ensure a successful outcome to our work. We would like to thank the Secretariat for the briefing and for the documents that have been submitted. We align ourselves with the statement delivered by the African Group and by the G77 in China, made during the general debate. We also align ourselves with the statement just made by the representative of South Africa just a few moments ago. Mr. President, in spite of the efforts made by UNODC and the numerous networks that have developed laudable international initiatives, we must admit that asset return continues to pose a significant challenge to the requesting countries. There is still a great divide between the requesting and the requested states. The countries that have fallen victim to asset transfers place emphasis on the principle of a rapid return of these assets of corruption to the legitimate states of ownership, and would hope that return would take place in as short a period as possible so as to ensure that the returned assets can finance the development of their countries. Now, the countries where the assets derived from corruption have been deposited, however, would prefer to refer to asset recovery, which implies lengthy proceedings, mechanisms, and verification, all of which are time-consuming. The requested countries are not always content with the arbitrary nature of asset return, the lengthy delays experienced, the stalling techniques that can be used, and legal and operational obstacles that have an impact at times on asset recovery. After long years of consideration, exchanges, and meetings on this subject, we now think that only a compromise between these two schools of thought will lead to progress in the way this difficult issue of asset return is handled. And let us recall, this is a fundamental principle of the United Nations Convention Against Corruption. Mr. President, the lessons that we have learned following the first review cycle as regards international cooperation and the exchange of experience as well as the various initiatives, such as those that have been implemented by focal point networks in the various parts of the world, and specific bilateral agreements between various countries, are all good practices that will serve to enhance the efficacy of mutual legal assistance and will serve to streamline extradition proceedings in combating corruption. Mr. President, launching the second review cycle, which we support, will enable the states parties to objectively evaluate the scope and the efficiency of Chapter 5 of the Convention. The ensuing recommendations undoubtedly will lead to a reconciliation between legal and judicial systems, which in turn will help overcome the difficulties and the obstacles that currently impede cooperation when it comes to asset recovery. Thank you very much.
Большое спасибо.
Many thanks. My next speaker is the Republic of Korea. Please take the floor.
Mr. President and distinguished delegates, I'm grateful to have this opportunity to share with you how Korea recently implemented the UN Convention Against Corruption and the progress it is making in cooperating with other countries with respect to asset recovery. Let me directly and briefly introduce a leading example of Republic of Korea's recent endeavors and international cooperation to confiscate criminal process related to its former president, Mr. Chun Doo-hwan. As you may be aware, former President Chun committed a series of crimes, including bribery, for which he was ultimately found guilty. He was sentenced in 1996, which included a collection order in the amount of $201 million. However, execution of the order faced various obstacles and thus proceeded slowly, with only 1/5 having been achieved by 2013. As a result, the Prosecution Service of the Republic of Korea organized a special task force team that implemented various creative investigations. The TF team was able to locate and confiscate a substantial number of additional hidden assets, such as precious artwork. It also discovered that the former president's son had been involved in using illegal funds to purchase luxurious property and make a number of investments in the US. Based on these investigations, the Supreme Prosecutor's Office of the Republic of Korea requests the US Department of Justice for immediate mutual legal assistance for asset recovery in August 2013. In February 2014, the US DOJ seized the property of former President Chun's son and also the invested funds. This was accompanied by procedures for civil forfeiture. Through this process, the US DOJ was able to collect approximately $951,000, which are currently scheduled to be remitted to Korea. It goes without saying that this meaningful recovery of assets was the result of close work and cooperation between Korean and US law enforcement authorities. Recently, we are involved in an MLA request for asset recovery from the US related to an anti-corruption case against a US official. One lesson that the aforementioned case and similar cases have taught us is that to achieve better implementation of the UN Convention, domestic laws and regulation concerning asset recovery, such as legislation on seizure and confiscation, should be organized at a national level. Further, active endeavor to eliminate obstacles blocking smooth cooperation between countries require close attention at an international level. For example, obstacles may encompass lack of trust and political goodwill and ineffective communication or unfamiliarity of a counterparty's legal system and requirements. The role of each state party and the international initiative, such as the World Bank Stolen Asset Recovery Initiative, is important in providing and improving knowledge, products, tools, and other resources in support of international efforts to trace, to recover, and return criminal assets. I look forward to further development in this area and can ensure that the Republic of Korea will continue its efforts against corruption on a domestic and international level. Thank you very much for your attention.
Большое спасибо.
Thank you. I now give the floor to Sudan.
سيد الرئيس أسمحوا لي
Thank you, Mr. President. At the very outset, I would like to express my deepest thanks to the Secretariat for the efforts that have been made to circulate the documents for this meeting. Delegation of my country, Sudan, is of the view that this chapter on asset recovery is a key part of the United Nations Convention Against Corruption, and thus we believe that it is through this chapter that the international community is in a position to identify embezzlement crimes and efforts to move assets to safe havens. Implementing Chapter 5 is really a challenge for states parties. Difficulties have arisen with the initial implementation of the provisions of this chapter. We believe that the challenges will continue to exist until such time as firm political will is displayed. We must respect the spirit and letter of the Convention. Implementing the Convention calls upon us to fill in the shortcomings in our national domestic legislation, to harmonize our domestic legislation with the Convention. We must move away from cumbersome bureaucratic approaches and adopt new procedures in such a way that would avoid us complicating implementation of Chapter 5. My country advocates measures to help countries that have been victims of embezzlement. These countries are the first that are entitled to recover those monies. They are the best positioned to benefit from the investment of those funds. They are developing countries and they need investment. We support the draft resolution that has been tabled by Nigeria to facilitate international cooperation in returning embezzled funds to their countries of origin. The government of my country believes that we ought to establish a link between the UN Convention Against Corruption and the Hague Convention on the protection of cultural goods, because organized crime groups are stealing cultural property and selling cultural property far from their countries of origin. This has been carried out in non-developing countries. We support the efforts on preventive measures and on asset recovery. We believe that the second phase of implementation review should provide us with an opportunity to improve our knowledge, to exchange our experience in these areas. We welcome the role played by the Intergovernmental Group on Asset Recovery. It's a very useful role, and it enables exchange of experience and knowledge, enables us to discuss challenges that are impediments to implementation by countries of Chapter 5. In my country, asset recovery is dealt with by our penal code. Furthermore, the rule on international cooperation adopted in 2014 contains detailed texts on measures related to MLA requests, notably when it comes to the recovery and return of stolen assets. Mr. President, as you are aware, assets stolen through corruption tend to be stolen from developing countries and end up in developed countries. And when it comes to recovering those assets, we would like to call upon the countries that are destination countries to return those countries to us, except where the requesting country undertakes to pay the cost of restitution. Mr. President, We've taken note of CAC COSP /2015/3. This concerns the progress report on implementation of the mandates of the Working Group on Asset Recovery. We've also taken note of document CAC/COSP /WG2/2015/4. This is the report on the meeting of the open-ended intergovernmental working group on asset recovery, which was held in Vienna on the 3rd and 4th of September 2015. Thank you.
Большое спасибо.
Thank you. I now call on Mali.
Monsieur le Président,
Mr. President, ladies and gentlemen, honorable guests, dear participants, good day. Mr. President, through the voice of Madam Minister of Justice and Human Rights, Guardian of the Seals, the Republic of Mali wishes to thank the Russian Federation for having given such a warm welcome in this magnificent city, and would once again also like to thank UNODC and UNCAC for their support. Given that it is one of the essential pillars underpinning the Convention, asset recovery and international cooperation are necessary measures in order to engage in the lengthy pursuit of dirty money. Indeed, every year it has been proven that acts of corruption, such as embezzlement of funds and other abuses of office, are perpetrated by the political elite and by international and national public officials. Mr. President, in order to combat impunity, in Bamako on the 26th of August 2015, the Council of Ministers adopted a draft bill amending the criminal code aimed at criminalizing acts of corruption of foreign public officials and the public officials of international public organizations, the embezzlement of goods and assets in the private sector, and proceeds related to these crimes. This draft bill is shortly to be put before Parliament. Mr. President, the time has come to ask the Western countries to engage in frank cooperation in order to prevent cooperation in our countries, and specifically in developing countries. They must ensure that assets of criminal origin are not deposited in their financial institutions. These assets must be returned to their countries of origin in order to strengthen the rule of law. And as such, steps must be taken in order to promote rules of good practice to support return in keeping with subparagraph A of paragraph 1 of Article 31 of the Merida Convention. Accordingly, the provisions of Mali's criminal code, enacted in Law 6066 of the 29th of December 2006, which is the harmonized law on combating money laundering, as well as the Code for Public Procurement and the Law 2014-015 on the prevention and suppression of illicit enrichment, address freezing, seizing, and confiscating. A state party can no longer use bank secrecy in order to refuse to implement the provisions of paragraph 7, Article 31 of the Convention. Mr. President, at the same time, however, while we have still not adopted legislative measures and enacted these in our internal legislation in order to regulate the administration by the competent authorities of frozen seized or confiscated assets under our paragraphs 1 and 2 of Article 31 of the Convention, Mali requires technical assistance, as international cooperation is the best way to combat impunity, corruption and financial crime. The Republic of Mali has signed and ratified numerous conventions in this area. From the day of independence, including the Convention of the African Union Against Corruption, the ECOWAS Convention on Mutual Legal Assistance of 1992, the ECOWAS Convention on Extradition of 1994, the Protocol on Combating Corruption of the 21st of December 2001, signed in Dakar, the Convention for Cooperation in Judicial Matters between Mali and France, signed in 1962, and a bilateral convention between Mali and Congo-Brazzaville, signed on 4th May 1962. Mr. President, yet, in spite of these efforts, there are still shortcomings. We must reaffirm that Mali, as yet, does not have provisions in place allowing us to tackle Article 26 of the Convention, in particular, mutual legal assistance extended in the context of investigations, prosecutions, and legal proceedings involving offences or crimes where a legal person or entity may be held liable in the requesting state party, pursuant to Article 26 I referred to previously. Nor do we have a provision that addresses witness protection or the protection of experts, victims, or individuals who provide information in keeping with the provisions of Articles 32 and 33 of the Mérida Convention. In order to address this situation, and with UNODC's support, in Bamako between the 3rd and 5th of August 2015, we held a workshop to draft a law on international cooperation in criminal matters in Mali in order to validate international texts, in particular extradition treaties and mutual legal assistance agreements. In order to strengthen the necessary capacity to address the challenges posed by organized crime in the Sahel, the UNODC experts worked with a small group of national experts chosen based on their skill, their rigor, and their integrity in order to draft a law on international criminal cooperation. Here, the aim was to compile in a single document the varied and various international texts in order to facilitate their reading and use, and, moreover, to add texts that as yet have been lacking to address witness protection and expert protection, in order to provide a comparative analysis and thus better guide our policies, institutions, and programs. For all of this, UNODC's technical assistance is necessary. Mr. President, let us recall that these events stem from an act of political courage which should be commended and which shall serve to ensure that international judicial cooperation in criminal matters has as broad a scope as possible, and that this is to be provided by and received by the Republic of Mali in the context of extradition, mutual legal assistance, investigations, prosecutions, and legal proceedings in the criminal sphere, in particular addressing freezing, seizure, and the confiscation of proceeds and other instruments derived from criminal activity or assets detained for terrorist purposes, as well as the transfer of individuals who have been sentenced and various custodial sentences. Mali has recognized its own deficiencies and therefore promptly seeks technical assistance in order to duly uphold the aforementioned convention. Finally, I would like to conclude by expressing the gratitude of the government of Mali and of the people of Mali to UNCAC, UNODC, and to the Russian Federation. Mr. President, I hope that my statement will be heard and that you will provide technical assistance. Thank you very much.
Many thanks for your informative statement. I'd like now to call on the U.S.
Thank you, Mr. President. Many delegations have noted frustration with the track record on asset recovery. We agree with them that much more needs to be done, but we shouldn't minimize the progress that has been made. Under the best circumstances, asset recovery is complex and time-consuming. As states parties, we still need to dedicate more effort to prevention, to establishing and maintaining capable, independent investigative and prosecutorial authorities and financial intelligence units, so that requesting countries can do the necessary groundwork that is indispensable to international legal cooperation. We need to share information about our laws with each other and build relationships between practitioners through domestic coordination and international coordination. We need to ensure we have adequate legal frameworks for confiscation and consider tools such as non-conviction-based forfeiture. And we need to build practitioner networks and informal information sharing, proactively used by requesting and requested countries. Progress on these and similar practical tools will do more to advance effective asset recovery than anything else. While political will is important, even where political will is very high, we still need to ensure these practical measures are in place if we want to increase the likelihood of success. That is the experience of the United States, which has very high political will to cooperate on this issue. The United States has a great deal of experience in asset recovery. We have made major returns to several countries. We have a dedicated unit of proceeds of corruption asset recovery specialists at the Department of Justice, and recently created a parallel dedicated squad of investigators from the FBI and other agencies. We have supported an extensive amount of capacity building and posted asset recovery advisors abroad to work directly with requesting countries. We have published a guide to our asset recovery laws and procedures in the 6 UN languages. We worked with partners in the G7, Middle East and North African countries in transition, Qatar, Morocco, and other regional and financial center partners to launch the Arab Forum on Asset Recovery. We then co-organized a similar meeting to coordinate among multiple jurisdictions on behalf of Ukraine. We are making progress. As Star has indicated, billions of dollars have been returned and the pace is increasing. We have had productive meetings of the Asset Recovery Working Group and heard not just frustration, but also success stories. We learned that countries are reforming their laws, creating new institutions, tightening their preventative measures and domestic coordination, using beneficial ownership transparency and other anti-money laundering approaches, and building and benefiting from international networks like CARIN and the Global Asset Recovery Focal Point Initiative, which now brings together asset recovery practitioners from over 100 countries. We commend India for hosting the next focal point meeting in early December. We have heard that while this is a work in progress, significant proceeds are being returned. We must use the foundation of our work over the last years and our lessons learned as we consider an asset recovery resolution for the 6th COSP. The most important goals of the resolution we adopt in St. Petersburg should be to maintain the balanced technical approach we have established over the past few COSPs and meetings of the Asset Recovery Working Group, and capture and reinforce the good practices we have identified over the last 2 years of practice and discussion in the working group. To continue to make real progress, we should avoid finger-pointing exercises and politicizing asset recovery. We should maintain the balanced approach we've carefully adopted over the several years of resolutions and working group meetings. Asset recovery takes effort by requesting and requested states. We should avoid departures from the convention that take us to issues far outside Chapter 5. We cannot renegotiate provisions and definitions that were carefully crafted over many years of negotiation. We do not believe that we should take decisions on sensitive issues that have not been discussed in any meaningful way in the working group, which brings together our experts and their practical experience. The excellent discussions of the working group have highlighted good practices that are worthy to be captured in any resolution. Requesting states and requested states benefit from law enforcement consultation, law enforcement to law enforcement cooperation, sometimes referred to as pre-mutual legal assistance, especially where one state is not familiar with another legal system or procedural requirements. Requested states can designate officials to give advice both on how to best formulate mutual legal assistance requests and on what kind of information can be given without a request. Practitioner networks and increasingly secure communications capacity can support such coordination and consultation. We should continue to share information with practitioners in other countries about our asset recovery laws and procedures. Many members of the G20, as well as Switzerland, Lebanon, and Jersey, have published user-friendly guides on their frameworks, often in multiple languages. This could be a model for states parties. In the area of tracing, given the maneuvers by criminals and their advisors, we should ensure that reliable beneficial ownership information on companies is accessible onshore to law enforcement, tax administrations, and other relevant authorities, including as appropriate financial intelligence units. We must continue to consider what legislative measures consistent with Chapter 5 will further facilitate freezing and confiscation of corruption proceeds, including the use of non-conviction-based confiscation, restraint based on formal request and receipt of evidence of an arrest or charge in the requesting jurisdiction, or restraint in the absence of a formal request, and confiscation of equivalent values in the absence of recoverable assets. We should also continue to stress prevention through measures such as customer due diligence and rules of transparency of legal entities. And since, fortunately, there is a growing body of practice in asset disposition, including asset returns, consistent with Article 57, we should begin to share models and lessons learned in that area more systematically. We must also continue to stress capacity building, but targeted practical training and mentoring based on solid curriculum. Officials who engage in corrupt acts should be held accountable by and to their own citizens whenever possible, and prosecuted by domestic authorities in their home countries. In all instances, a financial investigation should ensure an effort to identify and confiscate the proceeds of corruption. The greatest way to facilitate recovery of assets is to ensure that there are appropriate laws and mechanisms in place to prevent and deter corrupt activity in the first instance, to prosecute those involved in acts of corruption, to detect the illegal acquisition and transfer of assets derived from corruption, and to ensure that there are suitable mechanisms in place, both conviction and non-conviction based, to recover through confiscation the identified proceeds of corruption. It is also necessary that such laws be vigorously enforced and such mechanisms actively used. It is the responsibility of each state party, first and foremost, to enforce its own domestic laws against its own public officials who engage in corrupt acts, and to create the basis and appropriate legislative frameworks needed to recover funds stolen through corrupt acts. We have introduced a resolution to advance these practical tools and similar measures, advancing in a balanced approach consistent with our agreed requirements under the Convention. Mr. President, we have made progress in asset recovery. But we have even more to do. This is a full menu of the work for the COSP and states parties, but we must continue our commitment to effective asset recovery, strengthening our legal systems, building our capacity, and building trust and knowledge.
Mr. President, on the issue of international cooperation, we take the view that in any multilateral law enforcement convention, the international cooperation mechanisms set forth are among the most critical articles. The United States regularly provides or requests assistance regarding corruption offenses. Incoming and outgoing numbers during the past decade have well surpassed 600 requests and generally involve embezzlement and bribery. At least 70 times, again during the past decade, we have seen exclusive reliance on the UN Convention Against Corruption for the purpose of providing or requesting information from other parties with which we had no bilateral mutual legal assistance treaty. These cases have also generally involved embezzlement and bribery. With respect to extradition, we have identified at least 40 incoming and outgoing requests that have focused on corruption offenses, and we have identified at least 5 instances in which we invoked the UN Convention Against Corruption to support our request under an existing bilateral extradition treaty. On the issue of the UNCAC International Coordination Expert Group, during the last COSP, the conference agreed to hold back-to-back meetings of the UNTAC Working Group on International Cooperation and this convention's expert meeting on international cooperation. We applaud the wisdom of that course and note that it provides states parties to both conventions to send practitioners to discuss concrete measures to ensure effective implementation of both conventions. Indeed, we have studied the recommendations emanating from both meetings and see common recommendations. There is a focus on identifying, developing, and strengthening central authorities, developing and maintaining contact amongst operational counterparts, including the placement of liaison officers or magistrates abroad, ensuring staff is adequately equipped and trained to prepare and execute requests under both treaties, and developing means to track requests after submission. By our count, at least 25 countries sent experts to both meetings to discuss issues common to both conventions, as well as a few matters that arise more often under the UNCAC, such as confiscation. It is imperative that we continue to support the work of the practitioners and adopt approaches, as we did previously, to ensure that we are effectively utilizing their time and not duplicating efforts. We believe that the UNCAC Expert Group on International Cooperation has yet to prove its utility. The UNTAC Working Group on International Cooperation covers many of the issues addressed under the UNCAC Expert Group. The Asset Recovery Working Group under the UNCAC covers the other issues that are unique to that treaty. And the agenda of the UNCAC Expert Group on International Cooperation has remained relatively stagnant. We look forward to engaging with colleagues from other states parties in discussing the benefits of the groups and exploring paths for them forward. We thank the Secretariat on preparing the conference room paper on civil and administrative cooperation. It is a helpful summary of the many and varied approach in cooperation in civil and administrative matters. We are concerned, however, that the paper expands the object and purpose of Article 46 of the UNCAC Convention to the full discretionary aims of Article 43. Of particular concern is the express aim to avoid higher standards of proof. As we have said in multiple fora on many occasions, the United States supports the broadest possible measures in international cooperation and continue to do so. We nonetheless seek to preserve the Convention's object and purpose to fight corruption as a crime. We acknowledge that certain illicit activity is better resolved civilly or administratively, for instance, when a defendant has died or fled the jurisdiction where he committed the offense. But we also do not want to dilute the principal aim of Chapter 4 of the Convention. Thank you, Mr. Chair.
Большое спасибо.
Thank you. Next is Kenya. Thank you.
Mr. President, I wish to reiterate our earlier statement made during the general discussion and to add a few comments in relation to asset recovery. Kenya appreciates that the recovery of corruptly acquired assets serves as a big deterrent to engage in corruption. The main objective under Chapter 5 of the UNCAC is to ensure that the corrupt do not get to enjoy their ill-gotten proceeds. Towards attaining this objective, Kenya has put in place an elaborate legal and institutional framework for identifying, protecting, confiscating, and recovering the proceeds of corruption. The main laws on this aspect include the Anti-Corruption and Economic Crimes Act and the Proceeds of Crime and Anti-Money Laundering Act. These laws are mainly enforced by the Ethics and Anti-Corruption Commission, the Asset Recovery Agency, and the National Police. The Financial Reporting Center also plays a key role in tracing and identification of such corruptly acquired assets. Kenya has continuously adopted international best practices on asset recovery. To mention just a few, the country has an elaborate system for encouraging the giving of information on the whereabouts of such assets, including the identity of culpable persons, firms, and companies involved. Secondly, the legal framework allows for protection, preservation, and management of such assets pending the institution and finalization of legal proceedings in regard to the assets. This is done through processes such as freezing, confiscation, and appointment of receivers. I'm happy to report that through the use of such measures inter alia, Kenya has been able to recover substantial assets from corrupt suspects and return them to the public institutions from which they were stolen. Mr. President, this is not to say that we have not encountered challenges. The main obstacle on such recovery is that suspects always seek to conceal the assets through other persons, firms, and companies, and this makes it difficult and complex to unmask the genuine owners. It also becomes more complex when such assets or owners are outside the jurisdiction. We also appreciate that legal proceedings towards asset recovery, when coupled with existing constitutional freedoms and rights, pose a major challenge, and this leads to complex and lengthy proceedings. The asset recovery legal and institutional framework in Kenya is available to other countries under the principles of international cooperation. Kenya enacted the Mutual Legal Assistance Act in 2012, which enables it to accord assistance to other countries on the area of asset recovery in accordance with the convention. Kenya has also faced the challenge of repatriating stolen assets stashed in other jurisdictions. It is our observation that the complex legal procedures on asset recovery and repatriation prevailing in these countries make them a safe haven where the corrupt are able to accumulate and enjoy their ill-gotten wealth. Kenya demands that such countries must do more to demonstrate their willingness to enable and facilitate the repatriation of these assets by removing all obstacles and impediments in their laws. The requirements to be met by a requesting country must not be made too onerous or difficult to meet. I thank you, Mr. President.
Большое спасибо.
Thank you very much. Next speaker is Ethiopia.
Mr. President, colleagues, ladies and gentlemen, since this is the first time that I am taking the floor, let me, on behalf of the government of Ethiopia, thank the government of Russian Federation for the warm welcome and hosting this important conference of the state parties. Let me also express our sincere condolences to the families of the tragic event of last Saturday, where many lives were lost. Our thoughts and prayers are with all of you. Mr. President, fighting corruption is a national priority in Ethiopia. The political will of the government and its operational commitment has brought significant achievements in the fight against corruption, although we still have a lot of issues that we need to address in the future. Ethiopia believes and is committed in expanding ethics education, a reviewing of the working methods and procedures of the public institutions and public enterprises. In addition, we pay much emphasis on asset registration and declaration of the public officials, members of parliament, and the political appointees. Ethiopia believes that fighting corruption will not be effective without the active engagement and participation of the public at large. To this end, we are working hard with many different anti-corruption coalitions, both from professional and the mass associations and religious institutions. As far as international cooperation is concerned, Ethiopia is a signatory state to UNCAC, and the African Union Convention on Combating and Preventing Corruption is contributing its share in strengthening the coordination and cooperation of different parties in the campaign against corruption, both globally and regionally. Mr. President, asset recovery is one of the top agenda points in the anti-corruption strategy that requires serious emphasis of the government, which in effect contributes to the general socio-economic development of the nations. Asset recovery, and specifically the asset return, is also an essential, as it usually involves that the stolen funds are going back to the country where they were stolen and could be used to foster sustainable development goals. The Ethiopian government hosted this summer the United Nations Third International Conference on Financing for Development. 193 UN member states attended the conference and agreed on a series of bold measures to overhaul global finance practices and generate investments for tackling a range of economic, social, and environmental challenges, which concluded in the adoption of the Addis Ababa Action Agenda. This groundbreaking agreement provides a foundation for implementing the Global Sustainable Development Agenda that world leaders have adopted this September, the 2030 Agenda. Financial crimes such as corruption, fraud, and embezzlement generate significant profits. Often this money has been stolen at the expense of the public budget. These proceeds of crime are usually hidden outside of the country where the crime was originally committed and laundered through complex financial and commercial transactions, often spanning across numerous jurisdictions. The Conference on Financing for Development provided an opportunity to discuss the issue of stolen asset recovery and its return more broadly in the context of sustainable development. It allowed in a way that these two global agendas, namely the 2030 Agenda and the Global Anti-Corruption Agenda, have converged on this point. Asset recovery and the return of assets can contribute to sustainable development. First, large-scale corruption and embezzlement cases subtract public funds that should be used for sustainable development objectives in countries where public budgets are already stretched and resources are often scarce. And second, returning these funds is the most effective way to counter the perception that corruption is hardly ever punished. The recovery and return of stolen assets has been identified in paragraph 25 of the Addis Ababa Action Agenda as a crucial element towards financing of the 2030 Agenda for Sustainable Development, and that return assets can contribute to sustainable development impact in countries such as mine and benefit the poor. Examples show that returns have resulted in improvements in the health and education sectors and in the reintegration of displaced persons. In preparation of the Addis Ababa Financing for Development Conference, Ethiopia has played a crucial role in ensuring that adequate attention is being paid to asset recovery, resulting in a stand-alone paragraph in the outcome document. Ethiopia is aware of the ongoing international work jointly led by United Nations Office on Drugs and Crime, UNODC, and Italy, in the context of Rego Calabara process. We are also aware of the work done by Switzerland and the International Center for Asset Recovery with the Quinchat process. Both processes aim inter alia to review past experiences in returning stolen assets with a view to providing ideas and concepts for future returns. We welcome and support this process. We will seek to build on the findings of these two important initiatives and further this discussion. Ethiopia will therefore offer to host an international expert meeting to share experiences on asset return in Addis Ababa in late June or early July 2016. I thank you, Mr. President.
Thank you very much. Before I give the floor to the next speaker, I'd like to inform colleagues that the happy times when we could ignore the speaking time is now over. We only have a half an hour left, so we have 12 speakers, and that list may even become longer still. So please do stick to the maximum 5, outright maximum 7-minute speaking time. So please pay attention to that. China, please.
Mr. President, The Chinese delegation would like to commend the efforts by the Working Group on Asset Recovery and the Secretary, and is encouraged to see that asset recovery has received increasing attention from all countries, and the working methodologies of the Working Group has been more pragmatic and advanced. In recent years, the Chinese government has carried out many active efforts in asset recovery. On one hand, the national legislation has been improved. China amended the criminal procedural law. Several procedural provisions has been added, which provided for confiscation of proceeds of crime in serious corruption and bribery cases if the suspect or the accused has fled or died. These provisions fill the legal vacuum in related area and further build up the legal foundation for asset recovery cooperation based on the convention. Currently, while accumulating judicial practice, China is also studying and developing related supporting systems of better applicability with a sense of urgency. On the other hand, China actively promotes international cooperation. China attaches importance to including asset recovery-related provisions into agreements of criminal justice assistance and extradition concluded with other countries. China starts the discussion on concluding specific asset recovery agreement and has finished negotiation with relevant countries on one such agreement. Therefore, we have achieved important breakthroughs in this area. At the same time, the Chinese government makes greater efforts in the exchange with other countries. With seminars, bilateral consultations on judicial law enforcement cooperation, countries are able to introduce their respective legal system and practice and learn valuable experience from each other. With joint efforts, China has achieved successful cooperation with relevant countries on several individual cases. Cooperation in the asset recovery is faced with many difficulties, and the asset recovery on the basis of the convention remains less than satisfactory. Therefore, this issue requires countries to pay more attention and importance to. There are many elements at play, which includes factors such as differences in legal systems and whether there's sufficient willingness of cooperation and effective cooperation measures. The Chinese delegation would like to take this opportunity to propose the following. First, all state parties should strengthen political trust and cooperation. With cross-border transfer of assets of crime becomes increasingly serious, there is a growing need for international cooperation. We believe that the origin and destination countries should promote cooperation in spirit of cooperation, mutual trust, and pragmatism, deepen understanding of each other's legal system, and have thorough dialogues on concerned issues, and to overcome difficulties with the utmost sincerity. Secondly, the readiness and willingness of cooperation should be translated into concrete cooperation measures in individual cases. The Chinese government attaches great importance to recovering assets of corruption. We actively promote international cooperation and continue to promote national legislation. However, successful practice is far and few between, and most of the huge amount of assets that has been transferred to abroad by corrupt criminals has failed to be recovered. We look forward to the exchange and cooperation on individual cases in asset recovery with other countries and to explore practical and effective cooperation methodologies when working on individual cases. Thirdly, we should streamline procedures and evidential requirements as much as possible. Criminals use well-planned, well-disguised, and crafted money laundering methods, which makes it very difficult for requesting states to provide very comprehensive evidence, especially for cases at the detection stage. Requested states requires requesting states to provide comprehensive evidence based on its domestic laws. Otherwise, it will be very difficult to handle relevant requests, and this sometimes makes it very difficult and might cause significant burden to the requesting states. China suggests that state parties should discuss the minimum requirements for evidence and strengthen contacts between law enforcement agencies in asset recovery and carry out necessary joint investigation, work together to analyze and screen the evidence so as to counter corruption in a more effective way and to recover assets of corruption. Fourthly, we should extend cooperation channels and come up with new cooperation methods and further develop legal instruments on asset recovery. The legal basis for cooperation on asset recovery should include multilateral agreements between state parties and bilateral agreements or agreements on individual cases. The Chinese government encouraged the role played by all kinds of regional and international cooperation mechanisms and the full utilization of all parties' resources and potential, and to carry out practical cooperation. In terms of approach of cooperation, the Chinese government supports the use of criminal, civil, and administrative procedures in a flexible manner, and to strengthen the communication of competent authorities in asset recovery. Lastly, in order to promote the Convention's contribution towards asset recovery, the Chinese delegation proposed that on the basis of prior achievements such as case summaries in asset recovery and UN asset recovery website, we should further carry out efforts to study and develop guidelines that can serve as a reference for countries in their practice, or to study the feasibility and necessity of negotiating and concluding an additional protocol to the Convention for that purpose. Thank you, Mr. President.
Thank you very much, China. Before I give the floor to the next speaker, two announcements. Firstly, all forthcoming speakers, please stick to the 5-minute rule. We absolutely have to finish the discussions here on 5 and 6 this afternoon. And I'm going to avail myself of the rule that's in the rules of procedure. I'm forced to avail myself of that rule. I'd like to propose to the conference that at this stage we close the list of speakers. We have 21 speakers on the list right now. We've had additional speakers right up to the present minute. Colombia and Venezuela have just been added, and so that we have the possibility of finishing our discussions this afternoon, I suggest that we make a decision right now to close the list. Can I consider your silence to be approval?
Хорошо, я оглашу.
I will read out the list of speakers who have yet to speak. Pakistan, Philippines, Argentina, Morocco, Thailand, Indonesia, Madagascar, Stolen Assets Recovery, Joint World Bank and UNODC Initiative, UNCAC Coalition, and Transparency International Russia.
Yes. Senegal.
Senegal too.
Таким образом.
So really it would be impossible to add anybody else. So the decision has been adopted, therefore, to close the list of speakers. I now call on Pakistan.
Thank you, Mr. President, for giving me this opportunity. I'd like to speak on the subject of asset recovery because this is an area of high priority for Pakistan, as of all developing countries. Keeping in view the various obstacles to asset recovery as identified by the working group on asset recovery, such as general and institutional barriers, legal and operational barriers, there must be a clear and sound legal framework on asset recovery, because presently in a best case scenario, it is arduous, and in a worst case scenario, it is impossible. The legal barriers like overly burdensome procedural and evidentiary laws, excessive banking secrecy, cumbersome requirements to the provision of MLA requests, and lack of non-conviction-based asset confiscation procedures, etc., must be looked into sincerely in order to get these barriers lifted or made flexible. New initiatives must be taken like stolen asset recoveries, that is STAR, the initiative of the UNODC and the World Bank for the developing countries, and there is also need to strengthen coordination between various initiatives in asset recovery. I would further recommend that we must encourage and pursue all methods of informal assistance before initiation of formal MLA request, and the asset recovery facilitators / designated focal points must be trained and provided technical assistance for this purpose by the experienced asset recovery jurisdictions. Mr. President, Pakistan believes that assets recovery through robust international cooperation is one of the pillars of global fight against corruption. While appreciating the excellent work done by the working group, Pakistan would call upon the state parties to translate their political resolve into practical steps aimed at returning the proceeds of crime and corruption to the countries of origin. Not only the corrupt need to be denied access to their booty, but also the victim states need to be allowed access to what was legally theirs in the first place. Mr. President, I'm sure deliberations on this subject in the 6th COSP will bear fruitful results. In-depth study of Chapter 5 in the forthcoming second review cycle will also help in streamlining procedures for early asset recovery. I thank you, sir.
Большое спасибо.
Thank you very much. Next speaker is the Philippines.
Thank you, Mr. President, for recognizing the Philippine delegation. I wish to echo the sentiments of the distinguished speakers in the previous sessions that concerted global efforts are paramount to effective asset recovery measures. In line with the international standards on combating money laundering, terrorist financing, and their predicate offenses, as set by the Financial Action Task Force, the Philippines, through the Anti-Money Laundering Council, which is the country's financial intelligence unit, has entered into a memoranda of understanding with 38 counterparts, through which we are able to share financial information either spontaneously or upon request, which could serve as leads in the detection, identification, freezing, and confiscation of stolen assets and/or process of crime. Also, the Philippines has a legal framework on non-conviction-based or civil forfeiture proceedings by which the government may recover stolen assets or forfeit process of crime without need for prior criminal conviction. This non-conviction-based forfeiture has proven to be a very effective tool in recovering stolen assets. The Philippines also has existing mutual legal assistance treaties, or MLAT, with 8 countries. In the absence of an MLAT, the Philippines may still extend assistance to foreign states in the recovery of stolen assets and/or process of crime through its non-conviction-based forfeiture under the expanded anti-money laundering law. In the past, the Philippines has coordinated recovery efforts with Switzerland, Singapore, and the United States, which all found success. Through such coordinated efforts, close to $700 million have been returned to the Philippines. The Philippine experience, however, has not been without its share of challenges. Definitely, there remains a need to enhance the cooperation framework with respect to sharing information. Ways that further strengthening and deepening the relationship among the international community should be earnestly explored with innovation. Domestically, the Philippines is currently looking into the enactment of a law that will authorize concerned government agencies to spontaneously share information on the process of offenses under the Convention that may aid in their detection, investigation, prosecutions, or judicial proceedings, or might provide lead to a request by a state party under Chapter 56 of the Convention. In this regard, the Philippines would welcome cooperation with the UNODC and other key stakeholders. Thank you for your attention.
Большое спасибо.
Thank you. Next speaker is Argentina.
Thank you very much, Mr. President. Ladies and gentlemen, delegations, good afternoon. The Argentinian Convention on Asset Recovery has been addressed as one of our priorities in recent years. This is based on international efforts that have been made, launched here in this forum, as well as part of the Inter-American Convention Against Corruption, and also within the forum of the G20. Briefly, in order to help save time, and in general terms, asset recovery in Argentina is provided for under Article 23 of the Criminal Code, which addresses the seizure of proceeds and the confiscation thereof. There has to be a prior sentencing. The Criminal Code enables judges and magistrates to launch a criminal proceeding to adopt preventive measures in order to freeze assets. Confiscation in Argentina can also target legal entities who are benefiting from ill-gotten gains. As progress in our constitutional framework, I would also like to emphasize that towards the end of 2014, an asset recovery unit was established under the Office of the Attorney General, establishing thus a new national directorate for asset recovery. This directorate is mandated to provide technical assistance and to cooperate with all other prosecutors in order to trace, freeze, and confiscate gains. Since its inception, the Directorate has intervened in 19 cases and has adopted preventive measures to the tune of more than $150 billion. As part of these achievements, I would like to highlight the following. A further national entity has been established for the purpose of cooperation, working together with the Attorney General against money laundering and criminal activity, which also provides for confiscation orders and preventive measures to the tune of more than $180 million and more than 140 tangible assets. We also have the Anti-Corruption Office that I'm here to represent, which is able to participate as a protagonist. Currently, more than 100 corruption cases nationwide under the aegis of the Treasury of the Nation, which is a state institution, with a list identifying more than 30 cases to initiate civil proceedings for the purposes of asset recovery, again, to the sum of some $100 million. To conclude, briefly, I'd like to say the following to the representative of UNODC in the context of the usefulness of civil and administrative proceedings in this area. On this opportunity, I would like to support what was said by the UNODC representative, and we can also bear witness to the effectiveness of this. In this context, let me say that last year, Argentina provided assistance to the General Controller's Office in Colombia, a brotherly nation of South America, in the context of direct administrative cooperation for a case launched in Colombia, which was concluded successfully in a period of 6 months' time. Thank you very much.
Большое спасибо.
Thank you. I now call on Morocco.
Thank you, Mr. President. Ladies and gentlemen, we have to reaffirm here that asset recovery is not a mere mechanism of international cooperation in fighting crime. It is a field that has dimensions that go beyond the procedure and legal. It pertains to human rights. Indeed, asset recovery allows countries to enjoy financial possibilities to implement their obligations with regard to human rights through making citizens enjoy their rights, whether social, economic, or cultural. This cannot be done in the absence of effective measures to fight corruption and the extortion of public funds. We need to set standards for good governance, guarantee equality and equal opportunities to all. As we are aware of all this, we have always strived to bolster our cooperation in asset recovery. Indeed, every year we process scores of cooperation requests regarding the freezing, seizing and confiscation of proceeds of crimes of corruption. Since there are sometimes procedural hurdles due to the varying legal systems, we have tried to overcome these hurdles by cooperating with requesting countries through bilateral agreements, especially through our Article 713 of our penal procedure law, which gives precedence to international conventions, whether they are bilateral or multilateral. We have also organized many meetings and conferences to consider these difficulties standing in the way of international cooperation and the ways to overcome them in cooperation with various countries in the world, especially those that have bilateral agreements with Morocco. Morocco has introduced many amendments to its national legislation, especially by criminalizing illicit enrichment, as well as introducing confiscation of the value of funds and introducing bank secrecy. Indeed, banks are required to watch any receipt of funds or transfer of funds and disclose any suspect operations and transactions. So much so that the FATF has hailed Morocco's efforts in fighting corruption and the financing of terrorism. Based on that, the FATF has decided to take Morocco off its blacklists. This encourages our efforts on all levels, especially bringing our legal system in line with our international obligations, especially UNCAC, as well as the recommendations by FATF, in addition to creating a judiciary that is competent for adjudicating corruption offenses and enacting a law to protect victims, witnesses, experts, and whistleblowers. Ladies and gentlemen, the Kingdom of Morocco continues to draw upon this international convention in implementing the various mechanisms for cooperation and fighting corruption. Here, our country has set up a national strategy to fight corruption that includes many projects, such as creating a specialized unit for asset recovery, as well as returning freezing or seizing funds. Despite all the efforts made internationally, regionally, and nationally to guarantee the lack of impunity for offenders and guarantee the return of stolen assets, cooperation in this regard continues to face hurdles and difficulties which limit its effectiveness, such as the lack of specialized capacities and the different legal systems in relation to seizure, freezing, and confiscation, especially with regards to the non-conviction-based forfeiture or the civil confiscation. To ensure continued and effective international cooperation in asset recovery, we need to think collectively by sharing our successful experiences, establishing a framework to compile information and accumulate knowledge, and especially create an anti-corruption observatory as mentioned by the Marrakesh Declaration.
Thank you. Our next speaker will be Tainat.
Mr. Chair, in order to combat all forms of crime, including corruption, effectively, states have to rely upon international cooperation in criminal matters, which is considered to be one of the essential tools. Like many other countries, Thailand recognized the importance of the international cooperation in criminal matters, including extradition and mutual legal assistance. and has been using this mechanism to help enhance law enforcement among several countries globally. With the recognition of such importance, Thailand actively concludes the treaties on mutual legal assistance in criminal matters with many countries around the world. Every year, the Attorney General, as the central authorities, has received many MLA requests from state agencies of requesting countries. The requests are usually considered promptly, and with the fulfillment of such requests, this cooperation from us certainly helps facilitating criminal procedure in the requesting countries. It is important to note that the ASEAN member countries have been aware of the challenge of law enforcement to deal with the increasing crime, including corruption offense. As a result, 10 ASEAN member countries signed a treaty on mutual legal assistance in criminal matters, which is better known as the ASEAN MLAT in 2004. In order to facilitate mutual assistance in criminal matters among themselves, the treaty came into force after the ratification of all 10 member countries on 31st January 2013, and is now fully applicable to all ASEAN member countries. To continue strengthening our cooperation within ASEAN and many countries in Asia Pacific, Thailand sincerely thanks to UNODC for taking a very active role in facilitating regional activities to enhance international cooperation. Recently, the third senior official workshop on mutual legal assistance and extradition in East Asia and the Pacific was organized by UNODC in Bangkok between 1st and 2nd October 2015 and yielded very fruitful results. Central authorities from many countries had an opportunity to exchange their experience regarding obstacles and best practice. Many legal barriers, such as asset recovery and dual criminality issues, were brought to discuss to find the best solution throughout the conference. Mr. Chair, with regard to the international cooperation for the purpose of confiscation and asset recovery, Thailand has received quite a number of requests from requesting states. If the requesting state can comply with the conditions of our domestic laws and regulations, we do cooperate and seize such assets for requesting state and provide the evidence related to such seizure and attachment to the requesting state in order to punish the accused person. To implement the UNCAC, we are currently in the process of reviewing our domestic law concerning the asset recovery with an aim to remove existing legal barriers in order to strengthen our international cooperation in criminal matters with other countries. Lastly, prosecuting criminal matters is the process to bring them to justice, more specifically to the corruption offense. To have the prosecutor who are experts in this kind of case in place is indispensable. Therefore, the Office of the Attorney General has recently established the Anti-Corruption Litigation Office to ensure that we have the prosecutor who have the interest, knowledge, and experience in handling the corruption case, which will, in turn, result in successful prosecution. However, the commission of crime at present is not limited to one state. The measure to enhance international cooperation, including expanding regional partnership and effort to provide technical assistance to other countries, should be further promoted and strengthened in order to combat crime, including corruption, more effectively. I thank you so much for your attention.
Большое спасибо.
Thank you very much. Indonesia, please.
Mr. President, distinguished guests, ladies and gentlemen, one of the most important elements for the successful implementation of the Convention is to promote, facilitate, and support international cooperation and asset recovery. Despite the Convention dedicated provisions on international cooperation, nevertheless, in reality, it is an arduous, lengthy, and complicated process. We have observed that absconding and stashing assets to other jurisdictions have become a common practice in corruption cases. As for Indonesia, more than half of accused persons and convicts are now overseas. One of the key elements for efficient and effective cooperation is the intensive communication between requesting and requested states. When I said intensive communication, it means close coordination and communication at any level between requesting and requested countries through formal and or informal channel. Our experiences conclude that good collaboration resulted in freezing and confiscation of proceeds of crimes, while lack of communication or the absence of willingness to communicate, particularly from the requested states, resulted in the victory of the criminals. Mr. President, at international level, we see that the problems are even twofold. I'd like to briefly touch this issue in my statement. In the extradition cooperation, we experience delays and even a standoff in some cases due to a strict bilateral treaty requirement, despite the fact that we are member states of the convention. Because of the delay, some of the cases almost exceed the statute of limitation. I am certain that no one in this room disagrees with the term justice delayed is justice denied. Another pressing problem we encounter at practical level is the fact that the sought persons often change their nationality to evade extradition. We have several cases in this regard. While acknowledging the right of state to grant nationality, nevertheless, a sound mechanism should be in place that ensure that granting nationality does not favor criminals. But what we are facing now signifies that there are different levels of political will and implementation of the convention. To anticipate and redress this problem, we attempt to incorporate specific provision in our bilateral treaty stating that nationality of a sought person is determined at the commission of the crime. Mr. President, as we all understand that one of the most difficult part of asset recovery process is to have ongoing MLA proceedings in multiple jurisdictions. Our experience shows the same case we brought in multiple jurisdictions did not bring similar result. The same case means same proceeding and dockets as well as the same court judgment. The only difference is the will of the requested states and the respective event results. I don't have the answer, but I believe this is what the conference is meant for, to promote cooperation and reduce barriers between member states. I have high hopes that such a forum and its subsidiary organ could shift to a more concrete and practical approach of its future works. The last problem I want to transmit to this forum, but I believe in a positive way, relates to arbitrary means used by the corruptors to challenge execution against them. It has reached a level that threatens the integrity of criminal justice system and legal sovereignty of a state and even its international relation. We call it forum shopping by the corruptors to evade execution against them and their assets. To briefly describe the facts, the corruptors at large filed commercial claims to international arbitration forums against Indonesia and slickly produced the award to put aside criminal convictions handed down by Indonesian court by claiming, based on their own interpretation of the award, that Indonesia has breach of international law. Indonesia won the commercial case, whereby the award states that there were no expropriation and unfair treatment. Yet, the most interesting part is the part of the award stated that Indonesia has breached international law in the process in carrying out in absentia proceeding against the corruptors. Let me throw questions to the floor. Since when arbitration forum become a forum for appeal of independent court ruling of a state? Since when an international commercial arbitration has jurisdiction to rules on something beyond its jurisdiction and without the submission of the disputing parties? And now what happened? The corruptors are trying to sell one sentence in the award to state and jurisdiction where their assets were blocked. Mr. President, we'd like to use this opportunity to alert member states of such onerous practice whereby the corrupt individuals will use any means possible to escape justice. We at government level shall not let this happen. One of the important elements to prevent such practice is trust and commitment between the member states. The government, where the assets are located, have significant role in preventing this arbitrary practice. Thank you, Mr. President.
Большое спасибо.
Thank you. Next is Madagascar.
Excellencies,
Mr. President, distinguished delegates, since it's the first time that I'm taking the floor, I would like to convey to you, Mr. President, the condolences of the government and people of Madagascar with respect to the tragic events that have just hit the people of the Russian Federation. I'd like also to congratulate you on your chairmanship of this conference. You may rest assured that Madagascar will stand shoulder to shoulder with you in achieving the success of this conference. We'd like to thank also the Secretariat for their unequaled organization in a context of crisis. In a context of crisis, which has led to increased corruption, we in Madagascar have sought to prioritize good governance and the rule of law by adopting a national strategy for the implementation of the UN Convention Against Corruption. Our strategy takes on board the recommendations of UNODC experts and also the outcome of our peer country review. Madagascar has adopted a new strategy as part of our macroeconomic strategy with a view to increasing our outcomes. And we are seeking to fight all kinds of illicit trafficking and corruption, which is undermining the development of our country. Mr. President, we'd like to brief the conference to the effect that we fully concur with the statement made by South Africa on behalf of the African countries with respect to the efforts and the challenges indeed faced by developing countries in fighting transnational organized crime and corruption. We are fighting against trafficking in our national resources, so precious woods and precious timber and mineral resources. Trafficking has been discovered of objects from Madagascar, from in Asia, in Europe, and unfortunately, although seizures and confiscations have taken place in those countries, our Bureau to fight corruption has been unable to open investigations against offenders who are residing in Madagascar. This is the case for native tortoises that were seized at Charles de Gaulle Airport in Paris in 2014, and timber that was seized in Hong Kong. And we're seeing offenders taking refuge in other countries and managing their affairs from those countries. This conference will enable us to improve international cooperation and mutual legal assistance. We hope that we will be able to adopt a resolution that will enable us to address these challenges using simplified procedures that would be less cumbersome for developing countries. Thank you for your attention.
Большое спасибо.
Many thanks. The next speaker will be Colombia.
Thank you very much, Mr. President. Good afternoon, ladies and gentlemen, distinguished delegates. The Republic of Colombia recognizes asset recovery as a fundamental principle underpinning the Convention and a matter of priority for the conference. In connection with the 9th and most recent meeting of the Intergovernmental Open-Ended Working Group on Asset Recovery that was held in Vienna between the 3rd and 4th of September 2015, Colombia restated the usefulness of cooperation with administrative authorities for the purposes of asset recovery and the presentation of updated information As regards existing obstacles, we would like to highlight differences between legal systems, and that is why we would suggest aligning our national legislations in this area. We also note delays, the lack of responses from states to requests for information, as well as a lack of cooperation and insufficient trust between requesting and requested states. However, at the same time, we would like to highlight good practices which make it possible to expedite the asset recovery process, and also make it possible to open up channels for direct communication between the central authorities, as well as the streamlining and simplification of procedures in certain cases. In the same vein, we would highlight the importance of technical assistance activities, as well as capacity building, focusing on asset recovery, such as the activities that were carried out this year under the aegis of the Office of the Comptroller General in Colombia, working in cooperation with the STAR Initiative and with the Basel Institute on Governance. Accordingly, the Republic of Colombia supports the launching of the second implementation review cycle, focusing on the provisions of chapters 2 and 5 of the Convention. And perhaps the most timely and relevant issues for my country as part of our fight against corruption. In particular, the consideration of the provisions of Chapter 5, which may help to provide greater information for both requesting and requested states, which undoubtedly will also make it possible to identify new needs for capacity building in this area in order to further strengthen asset recovery efforts. Thank you very much.
Большое спасибо.
Thank you very much. Venezuela, please.
Señor Presidente,
President, distinguished delegates, the Bolivarian Republic of Venezuela is grateful for this opportunity to be able to express our concern as regards the issue of asset recovery. For Venezuela, difficulties arise when cases take on an international dimension as a result of linkages between corrupt protagonists and links abroad. In other cases, there is a need to help build trust between the states that are concerned, and efforts must also be made to overcome difficulties in terms of communications and to address weaknesses in international cooperation, in particular when it comes to mutual legal assistance. The Bolivarian Republic of Venezuela reaffirms its commitment to uphold the implementation of this convention and to extend the broadest possible international cooperation with all states that seek it, in turn seeking reciprocal efforts in order to ensure effective and efficient asset recovery. Distinguished delegates, we are facing organized crime, which means that our countries must work together in order to combat the scourge of corruption, and also in order to help recover the assets derived from the scourge, in order to protect our national economies. The economic distortion that is caused by the transnationalization of criminal proceeds derived from acts of corruption has an impact both on the requesting countries as well as on the requested countries. And that is why there is a need for political resolve in order to address this and to extend international cooperation on the part of all states involved. Venezuela expresses its political will to move forward in this sensitive area and urges states to forge networks that will make sure that there is no refuge anywhere worldwide where the corrupt can hide the criminal proceeds. All states gathered here today know exactly what to do in order to recover assets from abroad. And we have every certainty that in time we shall receive responses that satisfy the requests made. Once again, we wish to restate the need to ensure that the issue of asset recovery and prevention are closely examined during the second review cycle that has just been launched. Mr. President, distinguished delegates, thank you very much. Thank you.
Большое спасибо.
Thank you. Next would be Senegal. Thank you very much, Mr. President. Mr. President, as I'm taking the floor for the very first time, on behalf of the President of Senegal, Mr. Macky Sall, and the people of Senegal, I'd like to present to you my deepest condolences with respect to the air disaster that took the lives of more than 200 people. I'd like also, Mr. President, to congratulate you on your election and to assure you of the support of my delegation. I take this opportunity to also express thanks to the people and government of the Russian Federation for the warm welcome that we've had here. Mr. President, distinguished delegates, on behalf of the delegation of Senegal, which I have the honor of leading, I'd like to extend to you our greetings, and our greetings also go to every member of the Bureau. I'd like to recall that when it comes to combating corruption, that on the 14th of July 2005, 2 months after its adoption, Senegal ratified the Convention Against Corruption and subsequently undertook to transpose it into our national domestic legislation. The decision by Senegal to ratify the convention without delay is due to the fact that our country was aware, and had been aware for a few decades, of the challenges that surround the fight against corruption. When it comes to implementing the convention, my government has taken broad measures seeking to prevent and fight corruption, the laundering of the proceeds of crime, illicit enrichment, and then asset recovery. Among the provisions undertaken, I can mention the creation of a national office to fight fraud and corruption. This is OFNAC. This testifies to the strong political will of the President of Senegal, bearing in mind the major and broad powers that have been allocated to OFNAC. OFNAC was set up to replace the former commission that had been it was set up in 2012, and this previous body had only limited powers. OFNAC has as its main mission to prevent fraud, corruption, and related crimes, to prevent them by promoting good governance in the public and private spheres. It can receive petitions from physical persons and legal entities, including anonymous petitions. A hotline has been set up. We have a website. OFNAC has seizure and confiscation powers. It can seize and confiscate the proceeds of corruption, carry out investigations. It can receive declarations of assets from relevant persons. We've set up a department for receiving declarations of assets by physical persons. We've received declarations from the chairman of the National Assembly and certain heads of administrations, from the Prime Minister, from CEOs of private sector bodies, auditors, in transactions also where the amount is above 1 billion, currency not specified. We have electronic declarations of assets. We have a database for all of that. Following his election, the head of state filed a declaration of assets with the Constitutional Court. This is a way of preventing illicit enrichment. OFNAC also proposes legislative and administrative reforms that seek to eradicate corruption. It carries out studies and research, the aim being to come up with relevant proposals. We've recently completed the terms of reference for improvements to for the legislation. Bearing in mind the scope of OFNAC's authority and its commitments, this testifies to the commitment of the head of state to fighting corruption. There's no restrictions in terms of information or banking secrecy. Banks are obliged to provide us with information. The OFNAC also has, well, its powers pertain both to the public and private sectors. They report to the head of state, and the report is published. The report details investigations, and any investigations that are required are transmitted to the public prosecutor. Bearing in mind the importance of prosecution, we have developed a prevention strategy for sectors that are the most affected by corruption. We hope that this will lead to change in mentalities. This is the best way to prevent corruption, fraud, and illicit enrichment. Education and training are therefore at the very core of our tasks. Education of citizens, it's a very important part of our vision. We're trying to promote 4 types of culture: exemplarity, integrity, respect for public assets, and a culture also of accountability. As part of this approach, OFNAC carries out activities in close collaboration with civil society, the Network of Parliamentarians Against Corruption, the Ministry for Good Governance, and other oversight bodies. We've also put in place programs that enable us to come up with very good results when it comes to fighting corruption and money laundering. The adoption of the law on declarations of assets, which applies to heads of parliamentary institutions, the head of the Constitutional Council, and the head of the Economic and Social Council, and other top-level officials. This is an excellent measure when it comes to preventing corruption. When it comes to the review mechanism, Mr. President, we have completed our self-assessment. This has involved all kinds of protagonists in our country, and we've done this together with Croatia and the Comoros Islands. As part of the reform process, we have a draft law on the creation of an asset recovery agency. The recovery of assets is an excellent way to prevent corruption if properly carried out, to deprive offenders of the proceeds of their crimes. In Senegal, we've had court condemnations of high-level persons. Confiscation of assets has taken place, and we've done this together with the countries where assets are kept. Now, thanks to the commitment of all involved, we are going to soon begin our review under chapters 2 and 5. These chapters are very important for us because they concern asset recovery. Mr. President, I'd like to reiterate my country's commitment to carrying out the requisite reforms so as to better fight against fraud and corruption. So reforming the criminal procedural code, the criminal code, and also draft law on illicit enrichment, a law on the management of asset recovery, and also a law on access to information and the protection of whistleblowers. I'd like to reiterate my country's commitment to implement all of the provisions of the UN Convention Against Corruption, to facilitate its review mechanism, so as to... I do apologise, says the President. I've asked you to conclude twice already. Please conclude. My government is aware that having transparency is a sine qua non condition for fighting corruption. I'd like to conclude by thanking the Secretariat of UNODC and the ECOWAS group within UNODC for providing their support to our office and for designating focal points to help us. I'd like to conclude by inviting developed countries to be more vigilant when it comes to African knowledge and African expertise. I think that the best way to fight and prevent corruption and illicit enrichment is to prevent money being hidden in other countries. You shouldn't wait for countries to look for the money back. You should prevent people from putting their money in your countries. Thank you. President, thank you very much. World Bank, please.
Thank you very much, Mr. President, and thank you very much for the opportunity to address this conference. And we are very grateful also for the reference to the work of STAR that were made earlier by other speakers. Three main ideas. First, the absolute imperative of the full implementation of Chapter 5 of the UN Convention. This is very necessary because of the Convention itself, but also, as mentioned by other speakers, because there are other processes internationally that really put the asset recovery and tackling the proceeds of corruption at the forefront, in particular in the context of the Sustainable Development Goal, the financing for development, as well as the growing attention to tackling illicit financial flows. So the more we can collectively deliver on Chapter 5 of the UN Convention Against Corruption, the more we also contribute to those other processes and objectives of the international community. And I think the recent developments with financing for development and SDG in particular provide additional political commitment and political momentum on which it's very important to build. At the same time, as was discussed earlier, political commitment and momentum is necessary but is not sufficient, which leads me to my second point, which is the remaining gap between the assets leaving countries, including developing countries, and the actual recovery. So yes, indeed, there is progress, and we should build on that progress because it's a sign that when all the mechanisms are put in place, progress is taking place and we see results. But on the other hand, we are all aware of the remaining gap, and that should be a call for action for everybody, and all of us being mobilized around these objectives. And if I may, two issues that I wanted to flag in that context as very important contribution to closing the gap between what is needed to be recovered and what is actually recovered. The first one is all the work on beneficial ownership and transparency as a prevention mechanism for the laundering of the proceeds of corruption, but also because this is a critical impediment in asset tracing at the moment, and even more so when you look at international cooperation. So the more all countries make progress in terms of implementing beneficial ownership transparency, the easier it will be to prevent and detect corrupt assets. The second one, picking up on a comment during our STAR Day yesterday, someone's corruption case is someone else's money laundering case. And it's really important to bring all this together. It's only by working together that requesting countries will be able to make progress on asset recovery, and financial centers, advanced economy have a key role to play in preventing and, when it unfortunately happens, going after the proceeds of corruption. And we hope that the liberation of the cost this time will allow to give really a focus on beneficial ownership and this joint endeavor between the two parties. Third comment, which is on STAR contribution. So the Secretariat made many comments at the start on what we've been doing over the last years. I just wanted to update on how we hope to continue to contribute to these efforts going forward. UNODC and World Bank Management decided to extend the lifespan of the initiative, aligning it with the second cycle, so that will allow us to provide full support to the outcome of the reviews, and in particular when there is a need for technical assistance that is identified in the context of the review. And we'll continue to work along 5 lines: country engagement, policy influence, and supporting these 2 key objectives: knowledge development, partnership, and communication. And I want to spend a couple of seconds on country engagement, because I think that's really trying to address many of the comments that have been made earlier in terms of closing the information gap and making sure that there is a much better understanding between requested and requesting countries, help build trust between practitioners with engagement all along, and they talk together before getting to formal requests for assistance so that they are more likely to be accepted and acted upon. And third element, which is the capacity building of the practitioners, so that the cases that are built in requesting countries are more likely to lead to successful feedback from the requesting countries. And a lot has been done in that respect, but there is still a big need for capacity building and trust building. So with these words, I also wanted to thank the donor to the STAR initiative. This is thanks to them that we've been able to provide all the inputs that we have so far. We've got a very ambitious work program, clearly very strong needs have been expressed today and in the Asset Recovery Working Group, so we continue to count on their support, and we very much look forward to continuing to contribute to the full implementation of Chapter 5 and more generally the UN Convention. Thank you very much.
Большое спасибо.
Thank you. UNCAC Coalition, please.
Mr. President, distinguished delegates, ladies and gentlemen, I am most grateful for the opportunity to address the 6th Conference of States Parties to the UNCAC today. I make this statement on behalf of the UNCAC Coalition, a global network of over 350 civil society organizations committed to promoting the ratification and effective implementation of the UNCAC. Almost 2 years have passed since the last Conference of States Parties in Panama and the adoption of Resolution 5.3 on asset recovery. So one may well ask whether there has actually been any progress. What volume of assets has been recovered? How much has been returned to the countries where the predicate offenses took place? How has it been used? Has it benefited the victim populations? The answers to these questions are difficult to find, as to date, most states parties do not collect nor publish data relating to asset recovery. State parties also have yet to recognize the importance of the principles of transparency and accountability with regard to the use of returned assets. These principles, which are in strict line with UNCAC Article 9.2, are of critical importance. It was their absence that helped facilitate the diversion and theft of assets in the first place. In fact, justice cannot be served if only a half of the original abuses are addressed. And yet, the resolution on asset recovery that was adopted during the last COSP in Panama, just like the ones before, does not contain any language item regarding those principles. While the UNCAC Coalition welcomes the various ongoing and upcoming initiatives regarding the disposal of returned assets, it believes that those should not preclude states parties from recognizing the importance of the principles of transparency and accountability. The UNCAC Coalition is further concerned by the low level of implementation of UNCAC Article 53b. This article, which provides for the direct recovery of properties through compensation claims, was established to provide a concrete remedy to states harmed by corruption in situations such as bribery or trading in influence, where the proceeds of corruption involve funds of private origin, that is to say, assets over which victim states cannot establish prior ownership. However, many states parties have yet to acknowledge that the award of damages constitute a way of recovery under the UNCAC. According to a recent report produced by STAR, in the majority of foreign bribery cases settled abroad, victim countries are left out of the bargain. This is all the more unfortunate given the heavy and increasing reliance on negotiated settlements in both common law and civil law jurisdictions. Regrettably, those findings are believed to be equally true when it comes to ordinary court proceedings. The issue started to receive some attention during the last COSP in Panama. The resolution on asset recovery adopted on that occasion urged states parties to consider the use of the tools set out in Chapter 5 of the Convention when resolving cases involving offenses outlined in the Convention, including transnational bribery. The inclusion of this operative clause was clearly a welcome move towards a comprehensive implementation of UNCAC Chapter 5. However, the language remains unclear and misleading. In fact, Article 53b is mandatory, and therefore this provision has to be applied whenever a cross-border corruption case involves proceeds of corruption. To that end, states parties should be provided with a set of guiding principles to facilitate the implementation of UNCAC Article 53b, including best practice examples with respect to the identification, quantification, and reparation of the damage caused by corruption. Last but not least, the UNCAC coalition wishes to call on states parties to do more to prosecute corrupt officials and recover their ill-gotten gains. The resolutions on asset recoveries that were adopted during the last pre-conferences of states parties to the UNCAC all noted the particular challenges posed in recovering the proceeds of corruption in cases involving individuals who are or have been entrusted with prominent public functions. The resolution adopted in Panama, just like the one adopted in Marrakesh, expressed concern that some persons accused of crimes of corruption have managed to escape justice and thus have eluded the legal consequences of their actions. Likewise, the resolution that was adopted in Panama stressed the need to hold corrupt officials accountable and urged in various parts of the resolutions states parties to actively and robustly pursue domestic investigations and prosecutions of those engaged in acts of corruption. All these language items are welcome. However, the resolutions that have been adopted so far, including the last one in Panama, all failed to address the issue of immunity, which, in practice, prevents such proactive enforcement action from taking place. Immunities are indeed a major obstacle to the effective prosecution of corruption offenses. This was confirmed by the report produced by UNODC on the implementation of UNCAC Chapter 3. It is critical to limit the scope of domestic immunities. It is also essential for democracy and the rule of law to have procedures in place in order to lift domestic immunities and to hold corrupt officials accountable. In that regard, the recent decision of the Congress of Guatemala to lift President Otto Perez's immunity over a corruption scandal there shows how important such limits are. Such limits have to be extended to foreign and international immunities, which are regularly abused. These are blatant violations of the international rules on immunity, which are not meant to benefit individuals, but to ensure the efficient performance of state functions. The UNCAC coalition believes that immunities of convenience, granted for the sole purpose of escaping legal proceedings or hiding stolen assets, should be ruled null and void. It further believes that the time has come for the international community to re-evaluate the international rules on immunity. Personal immunity should be strictly limited and in any case should not apply where crimes of international concern, such as grand corruption, are involved. In that regard, and while a recent study by the Institute for Economics and Peace, based in Sydney, just found strong evidence that high levels of corruption is a leading indicator for political instability and insecurity, the UNCAC coalition believes that it is high time for states parties to recognize the seriousness of the crime of grand corruption. Since the 2013 resolution on asset recovery, many more millions of dollars in much-needed funds, including money destined for health, education, and poverty alleviation, have been stolen and deposited abroad by corrupt agents. The few have enriched themselves at the expense of the many for too long, and it is essential that states parties address these failures to adequately prosecute the corrupt and recover the proceeds of their crime. I thank you for your attention.
Большое спасибо.
Thank you very much. Transparency International, please.
Глубоко уважаемый президент.
Esteemed President, distinguished delegates, on behalf of Transparency International Russia, I'd like to make the following statement. The events that led to the Arab Spring and to the fall of the Yanukovych regime and to the so-called Latin American Spring were caused by high level of corruption and illicit enrichment by the governors, the rulers of those countries. Hundreds of millions of dollars were taken out of those countries and placed in Western countries. I'm going to talk about a few matters related to implementation of or improvement of Russian legislation, and also this is applicable to other countries. For the purposes of implementation of Article 31 of the Convention, we need to take specific actions. Confiscation should also apply to substitute assets and funds that have been received illicitly. Conservative measures need to be taken, such as seizure of assets, freezing of money, and so forth. This needs to apply to substitute assets also. For confiscation, we need to ensure that there are conservative measures. This needs to apply to substitute assets too. We have measures such as confiscation, which are contained in the Russian Penal Code. Article 140, blocking of accounts also needs to be possible. In addition to creating legislative provision for using replacement assets, we need to enable confiscation of converted and mixed assets. Assets that have been mixed with other assets need to be able to be confiscated, such as when somebody uses money to buy a legal entity. In addition, the body that will carry out investigations to search for assets, they need to organize. We need to also have a centralized agency to ensure the integrity of returned assets. When it comes to immunity from prosecution, the Panama and Marrakesh declarations underscore the need for improving accountability. We need to lengthen the statute of limitations for corruption crimes, particularly when it comes to people who are in power for a long time. This is also due to the complexity of international legal cooperation and so forth. The speaker is speaking too fast. He really needs to slow down. Where there is persons who have political influence, the statute of limitations needs to apply after they have left office. At a practical level, we need to establish a separate body for asset recovery. We need to have a broader oversight measures. We need to be able to identify the beneficiary owners of stolen assets. We need to set up a separate agency. We need to introduce ad hoc prosecutors also. Asset recovery specialists need to work hand in hand with investigators from the very beginning of an investigation. The people in question need to have the right qualifications and authority so that they can work hand in hand with their foreign colleagues. They need to be able to receive and give informal cooperation and assistance. This can be financed from the recovered assets themselves. In accordance with one of the articles of UNCAC, we need to set up an appropriate mechanism for exchange of information with the competent authorities of other countries. We also need to have a more open and understandable procedure for including people in the Interpol list. Distinguished colleague, you have no more time. Please conclude in the next minute. At the international level, we need to have a procedure for cooperation between countries where assets have been frozen. We need to have better international cooperation in general. Thank you. Thank you for your intervention, says the Chair. That brings us to the end of this item of our agenda. Thank you for your informative statements, and thank you for your discipline. Thanks to that, we've been able to stick to the allocated time and complete the discussions within the allocated time. These discussions on this very important issue, which we've just concluded, I hope that they will enable delegations to agree on a balanced resolution. And this is one of the resolutions that are being discussed in the informal meeting. At the request of the Secretariat, I need to make a few announcements. Firstly, just to recall that today, in honor of this sixth session, at 7 o'clock in the Alexandrinsky Palace, the Governor of St. Petersburg is hosting a reception. Starting at 6:30, the shuttles will be taking people from here to the reception venue. The cultural program will include performances by artists, and that will happen as of 8 o'clock. Second announcement is as follows. The meetings of the regional groups for Africa and other groups will take place tomorrow morning at 9. This will be in CMF room. And the third announcement is as follows. The informals on L5 will take place tomorrow in conference room F at 10. Thank you very much for your cooperation in this afternoon's session. I wish you success for tomorrow's meeting. The meeting is concluded.